institutional independence of other constitutional bodies, such as Parliament. That is the elephant in the room. And I would like to submit the following. This court, that doctrine of restraint, because the National Assembly is a constitutional institution.
My Lord, Your Ladyship, I ask this bench of three judges to consider and appreciate
that institutional independence can only come into play where that independent institution is acting within the four corners of the Constitution. Because that is what Article 2 says. Everybody, including the National Assembly, is bound by the letter and the spirit of the Constitution. So where the National Assembly is acting in an unconstitutional manner, it cannot be right. That doctrine of institutional independence does not apply where that institution is acting in violation of the Constitution. It will be a very sad situation for this court to say, we will not interfere in independent institutional independence, where that institution is violating the Constitution. The petitioner's rights under Article 50, which in terms of Article 25C cannot be limited, were violated. And Article 22, 23 gives this honorable court power even where rights are threatened. Here they have been violated. So we ask you, with respect, to give very temporary stay, staying the consideration of the impeachment of the resolution of the National Assembly by Senate to afford time to this honorable court to hear this petition and those weighty issues. We are not just dealing with the Deputy President here. We are talking about constitutionalism. The Kenyan people in a presidential system retain the residue or handover. My Lord, Your Ladyship, people of Kenya elect a leader. They do not elect a semi-god. We don't want to go back to the imperial presidency. Think about the Kenyan people and about the future. 2 minutes.
My Lords, my good and learned friend, Mr. Paul Waluta, has donated 2.5 minutes to me so that I can follow Mr. Paul.
Yes, thank you.
Yes. My Lords, following what my learned senior says, and I agree entirely with him, allow me to draw your attention to the response that you'll be hearing, because that also was the summary in your brother Justice Mwita's ruling earlier today. The only basis upon which he said that conservatory orders might be suspended was the question of separation of powers. That is what will be addressed. You will be told about a case called Justin Mate. You will be told about a case called Kawera Mwangaza, a more recent one in Nyeri, where the issue of separation of powers was an issue. As regards Justin Mate and Mwangaza Kawera, those were cases where the orders were sought prior to debate at the county assembly. Those are not applicable to this matter. But my good and learned friend, Mr. Milimo, will be giving you a case called Mwangi Wedia and two others versus Speaker Murang'a County, where at paragraphs 92 and paragraph 93, your brother judge, the late Justice Obuto, also dealt with the question. Please look at the, and this with tremendous respect, at the issues that Justice Chacha Mwita addressed as regards substantiveness and the violations of the constitutions. Those decisions, including the Mwangi Wedia decision, are all overtaken and all did not take into account a decision by the Court of Appeal, which is more apt and which is more on all fours with this case. I refer you to the case of Martin Nyaga Wambora and 3 others versus Speaker of the Senate and 6 others. It's reported at 2014 EKLR. I am now referring to paragraph 53, the second half of paragraph 53. It is directly on this question, and this is what they say. Though the process of removal of a governor, and for these purposes we can insert their deputy president, from office is both a constitutional and a political process. The political question doctrine or separation of powers cannot operate to oust the jurisdiction vested in the High Court to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or of any law is consistent with or is inconsistent with or in contravention of the Constitution. And your brother judge, Justice Mwita, this afternoon, dealt at quite some length with the power and the jurisdiction of this court under Article 165 to intervene in cases where it is clear, it is manifest that the Constitution has been violated. And the only question becomes, do we allow a two-step process where the first step is invalid on account of constitutional violations? Do we then allow that to proceed? The answer is provided in a case I've shared with my friends here, and I brought extra copies for the court. This is the case of Omega Enterprises Kenya Limited versus Kenya Tourist Development Corporation and 2 others, reported at 1998 EKLR. In those days, the paragraphs were not numbered, but I'm referring to a passage at page 6 of 13. And this is what it says. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declared to be so. And every proceeding which is founded on it, it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. In the second paragraph, you'll find at the top of page 7, I will not read it, but where the judges there in the Court of Appeal said that anything done in violation of a court order, in this case a constitutional provision, is a complete nullity, since with such a faulty foundation, the entire house of cards must collapse with much ado. Allow me to say this. In 2014, I believe it was June, July, the Honorable Justice Mombin Ngugi, as she then was, stopped the Senate from deliberating on the impeachment of Governor Kivutha Kibwana. That decision is not reported. I'm not able to find it. These proceedings are being hurried at the Senate, the National Assembly, but the court with resources will be able to get that decision. The Senate was stopped from deliberating the impeachment of Governor Kivutha Kibwana in 2014 June. There is precedent for what you're being asked to do. Thank you for the privilege of your attention and your time. Thank you.
Thank you.
Thank you very kindly, my lords. I stand to add my notice of motion dated the 30th of October, supported by supporting affidavit, and a further affidavit, your lordships, dated.
Your motion is dated?
The 30th of September. And a further affidavit, your lordship, filed before this court, dated 9th of October. Your lordship, permit me to draw your attention to paragraph 15 and paragraph 20 of my motion, which form the basis upon which Justice, the brother Justice Mugambi considered when bringing this matter for in Parliament.
That is of the affidavit.
That's on the affidavit and the notice of motion. Your lordship, those are the grounds upon which we urge that this application qualifies under the case of Peter Katerau Munya to have made or to have gained the grounds of forming a prima facie case. Subsequent to which, your lordship, a conservatory order can ensue. Further to that, your lordship, the question of public interest, your lordship, in this matter is paramount to the extent, Your Lordship, the petition is seeking to look or to protect and uphold the Constitution and Article 3 of the Constitution. Your Lordship, while granting the order sought, consider the paragraphs 7, 8, 9, 10, and 11, and 12 of my affidavit. And Your Lordship, you confirm that this is one of the applications that meets the threshold in the case of Peter Gachagua Impeachment. Your Lordship, permit me to associate myself with the submissions made by my senior learned friends, but also invite Your Lordship not to tie yourself to the traditional doctrine of separation of power as expounded by Montesquieu. Your Lordship, the current constitutional dispensation in regard to separations of power, Your Lordship, has lost its virginity as it was described by Montesquieu. In the sense that, Your Lordship, this new constitutional dispensation has put the people at the middle of all government organs functions. And Your Lordship, when the people were enacting Article 10 of the Constitution, they enacted Article 10 in mind of holding organs, be it judicial organs or parliamentary organs, accountable to the people of the Republic of Kenya. And those organs are being dictated that they must observe the rule of law as and when they seek to dispense with their functions. That is to mean, Your Lordship, if Parliament failed to abide by the Constitution, then the functions or what ensues therein after is subject of interrogation and review by this Honorable Court. That is to mean, Your Lordship, that the doctrine of restraint cannot be viewed on a straight jacket. It must be viewed on case-to-case basis. That is to mean, Your Lordship, if an organ has violated the Constitution in pursuit of its functions, then this court cannot hide behind the veil of judicial restraint. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate and the Attorney General.
Just for emphasis, are you saying that the doctrine of separation of powers is no longer applicable in our constitution? Let power is given to the people.
Not as described by Montesquieu.
Can you expound, please?
Your Lordship, Montesquieu speaks that these three arms of governments must operate distinctively and independently. But Article 165 of the Constitution, 3(2)d, has given you the power to interrogate the functions of any organ in this republic. That is when the separation of power lost its virginity. Your Lordship, permit me to invite you to look at the case of the Speaker of the Senate versus the Attorney General, 2013 EKAR. And the Supreme Court is saying, we would state as a legal and constitutional principle that courts have the competence to pronounce on the compliance of a legislative body with the process described for the passing of a legislation. In this case, the process for the impeachment of the Deputy President of the Republic of Kenya. These courts have the competence to interrogate and even issue an order to preserve the process. Your Lordship, the courts are saying in the case of Doctors for Life that when the courts are to intervene, the courts will look at the consequences of the actions being sought to be restrained. For this case, Your Lordship, if the impeachment is to be allowed to proceed, it will culminate into the violation of the Deputy President's rights under Article 38. This process have the ability to limit the rights under Article 38. Whereas Article 38 says that if you are elected, you have a right to hold that particular office. That is to mean, Your Lordship, that if Parliament and the Senate is to limit the rights under Article 38 of the Deputy President, the same must qualify under Article 24 of the Constitution. It must be reasonable, it must be lawful, it must be justifiable, it must be acceptable in a just and a democratic society. Finally, Your Lordship, I invite you to look at the case of Commission for the Implementation of the Constitution for the National Assembly, again 2013 EKR, and also, Your Lordship, invites you to look at the case of Martin Nyakawangora, a matter that we urged with my senior Paul Moite, senior counsel. The courts are saying that judicial restraints must not, however, be an excuse for the dereliction of constitutional duties. If the court has been empowered to conserve a particular situation so as to inhibit the violation of the Constitution and Article 258 of the Constitution, then the court cannot fold its hands to that particular constitutional duty. It's my humble submission, Your Lordship, that this is one of the cases that the court can issue conservatory orders. London is not burning. The Senate is not wasting away. Your Lordship, I urge you to uphold my motion and grant the conservatory orders as sought. But as you do so, Your Lordship, also look at the famous case of Marbury versus Madison. Further that, Your Lordship, the case for Doctors for Life is also a relevant case for your consideration. That is 206. The courts are saying that as long as you have gone outside your constitutional ambit, this court can uphold the Constitution, should rise and protect it under Article 3 of the Constitution, and most importantly, uphold the supremacy of the people. In what sense, Your Lordship? That public participation was never done. And even as we reach tomorrow, Your Lordship, it is going to be done in the absence of public participation. This court will take judicial notice that the Senate, as it sits tomorrow, it has not called the people of the Republic of Kenya, pursuant to Act 118 of the Constitution, to conduct public participation. There is no one who is immune from judicial scrutiny. Not the Senate, not the National Assembly, not ourselves. Your Lordship, penetrate the doctrine of restraint, judicial restraint. Let this court penetrate it. Most obliged.
Thank you.
Your Lordship.
So in effect, Mr. Ndegwa, your application substantially is the same as Senior Counsel Mute's application.
Yeah, precisely. Only that mine is done by Mwananchi, who is asking the court to penetrate the doctrine of restraint.
Okay.
Yes, Your Lord. My application is dated. This is 6 of 2024.
Counsel, your name?
Kirago Nduta. Sorry.
Mr. Kirago Nduta. Watuta. Yes.
For the second petition. Yeah, I wish to associate myself fully with the submissions by...
Sorry, Counsel, what is the date of the application?
My matter is 537.
Then the date of the application?
6th of October, 2024. I wish to associate myself fully with the submissions which have been made by the three councils who submitted before me. And the application is similar to theirs. Say that, my Lord, I want to submit only on one prayer number 9, that this court grants any further orders that this honorable court deems fit in the interest of justice. I will argue only that prayer. The facts that support this application, and indeed the petition, are not controverted. There was not replied to. There is no application on it. And this is not responsibility. Is that prior to the debate in the National Assembly, of that assembly, as well as the Deputy Speaker, on different occasions, pronounced themselves that they support the impeachment motion. Article 50 of the Constitution requires that a person is entitled to fair trial, which includes that such a trial before a court or anybody must be done by a body that is impartial. At Article 25, that right cannot be limited at all. Therefore, the proceedings that took place before the National Assembly fall short of Article 50 as read with Article 25. I do not wish to repeat what my learned senior, Mr. Tom Masharia, submitted, but actions that are contrary to the constitutions are unconstitutional and therefore need to be declared null and void. So, in arguing the prayer for the appropriate remedies, Article 145 on the process of impeaching a president, which is the same process that is for impeaching a deputy president, Sub-Article 7 of Article 145 provide that these are the tail end of the process before the Senate. If at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the president shall cease to hold office, and in this case, the deputy president, because that provision applies mutatis mutandis. So, in the event that the process of impeaching the deputy president goes on and he is eventually impeached, my lord, this court still has power to make an appropriate remedy to prevent further violation of his rights. And those are the rights that we have described in our application and our petition. What is that appropriate remedy, Lord? In the case of David Ndi and others versus the Attorney General and others, it is 2021 EKLR. That's the BPI case. A 5-judge bench considered the question of an appropriate remedy And that appropriate remedy is traced at Article 23 of the Constitution. That is sub-Article 3 of Article 23, what it says, in any proceeding brought under Article 22, a court may grant appropriate relief, including a declaration of rights, an injunction, a conservatory order. And in that case, the court gave the reasons, and the outcome in this case was that, fine, let the process go on. But at paragraph 44, allow me to read how the court concluded in that case. Accordingly, the order which commends itself to us as the appropriate relief in the circumstances to preserve the subject matter of the consolidated petitions, and which we hereby grant, is that the assent contemplated under Article The assent contemplated under Article 256 sub-Article 4 of the Constitution, if it were to be given to the Constitutional Amendment Bill 2020, shall not come into force until the determination of these consolidated petitions. So, if the Senate were to proceed with the impeachment motion and conclude it and confirm the impeachment, my Lord, the appropriate relief would be to stay that impeachment until the consolidated petitions are heard and determined. And that is